There has been a radical plan put forward by the Australian Small Business and Family Enterprise Ombudsman, say that quickly if you can, Kate Carnell, in her Access to Justice report, to shake up the Federal Circuit Court by adding a specialist small business jurisdiction. This is to rectify an outdated system that has bankrupted families and favoured, unfortunately, deep-pocketed big companies over Australia's small businesses. If you've been in business for a long time, like me, more than 3 decades, it's inevitable that at some point you have legal issues. Unfortunately, a positive outcome could depend on how deep your pockets are and what kind of risk appetite you have. But just how likely is it that this plan could become a reality? Will small businesses get access to justice at a price they can afford? Well, today we speak with Pauline Wright, President of the Law Council of Australia, to find out. Welcome, Pauline.
Thanks very much. It's good to be with you.
This, for me, as a small business owner, as someone who speaks to thousands of small businesses weekly, this was a great piece of news. But, and I'll put in the big but, and I'm sure we'll follow up with a few of those as well, how likely is it, Pauline, that this will become a reality?
Look, that's impossible to say at this point. It's early days, but I would have thought that it's something that the small business community is going to welcome. The Law Council is going to consult with our small business committee, and we'll be speaking to people across the country about that to see what their response is. So it's very much early days, but in principle, anything that is going to make it quicker, cheaper and more fair for small businesses to get access to justice has got to be welcomed.
So is your official position as President of the Law Council of Australia, this is a positive and you guys are right behind this?
Well, that's right. I mean, at this stage, we haven't consulted with our constituent bodies, but my view as the President is that anything that is going to make the courts more accessible to small businesses is going to be welcome to the community out there who, so many people in our community are engaged with or employed by small businesses, and yet they face big hurdles when they come before the courts in terms of the likely costs, the potential for costs orders, and all of those things are very difficult for them where they're facing adversaries with very deep pockets.
So, and apart from the fact that it's emotionally draining to get into any kind of legal dispute, the reality is, though, that disputes do happen, and if you are in business of any kind, inevitably at some point in the lifespan of the business or as a business owner, you're going to face these hiccups. And that's just the reality, right? It's the cost of doing business.
Well, it is. And I mean, the best thing you can do to avoid having legal troubles is to have your systems, your contracts drawn up and properly advised upon at the start. So what you spend in setting up your systems and your contracts in the first place is going to save you a fortune down the track in terms of litigation, because once you end up in court, the costs can be astronomical, and that's what you want to avoid in small business.
And it's all the prep, it's the pre-work, it's the due diligence that you need to do to mitigate the risk, planning ahead, allowing for problems. There's nothing wrong with admitting that there could be problems. It's too late after. You can't. It's closing the barn door when the horse is already bolted, right?
That's exactly right. So if you have advice at the outset when you're about to enter into transactions with other people, getting that advice at an early stage is better than trying to fix it up at the end after the damage is already done, and you end up spending hundreds of times more than you would have had you got advice up front.
Now, fair and equitable access to justice is normally only be considered for an individual. But the reality is that small businesses, as you said, we employ so many people. In fact, almost half the workforce of Australia is employed by small business. And it's unusual when you single us out and we reflect on it now. We're actually a part of the world that doesn't have access to low cost or free justice or legal advice. The individual does, but not a small business owner.
That's right. So we enable individuals facing problems to have access to legal aid, for instance, although it's only the bottom 8% of income earners who have access to legal aid. But there are avenues for you to get legal assistance if you're an individual. But we don't have those sorts of things available for small business. And yet they account for almost 98% of businesses in Australia. And there are relatively few options for free or low-cost legal help as compared with individuals. So we do need to see that improve. We know that 22% of small businesses, as reported by the Ombudsman, were involved in a serious dispute in the last 5 years, and 62% sought legal advice either from a lawyer or a community legal service or another kind of legal service.
So we know that entering into a dispute or going into court is an expensive situation, and sometimes small business owners, you get legal advice. No one can give you a 100% guarantee. You move forward, particularly if you know that you've been wronged or that you are due a lot of money. So you get the courage up. You might move forward. But another part of the access to justice that the Ombudsman is referring to is another expensive part of the matter, where if something goes wrong in the case or the result is not in your favour as a small business owner, it's the costs order that can also cripple you and is what stops us actually from moving forward. And that's something that the Law Council is addressing as well, as brought up, and that Kate has brought up. The cost orders, if you're up against a big entity, they've got big pricey lawyers, the cost orders are going to be immense.
That's right. So if you as a small business owner have a dispute with a large business or a government department, the large business is going to have much greater resources than you do. And yet they may owe you significant money, or you may be defending a claim that they bring against you. And the usual kind of order in the courts is that if you lose, you pay the other party's costs. And that can be enormous. If they have a team of lawyers, including the solicitors, a team of solicitors, a junior barrister, a senior counsel, you could be up for literally hundreds of thousands of dollars just in legal costs for the other party. Plus, you've then got your own costs on top of that. So taking that risk in commencing proceedings is really a big step for somebody to take. So quite often we see small business owners not bringing proceedings, even if they're owed quite a lot of money, because they're afraid of the consequences if they lose in terms of having to pay the other party's cost.
And what does the report recommend for this?
The court recommends an opt-in system where you decide, it's called a no adverse costs order. So it's an opt-in system whereby costs are borne by each party effectively. So
regardless of the outcome.
That's right. So your risk is the cost you pay for your own legal representation.
And or if the matter goes whichever way it falls.
That's right. So it just means that each party bears its own costs, and that is something that other courts do. For instance, you look at the in Class 1 proceedings in the Land and Environment Court of New South Wales. There's no ordinarily there's no order as to costs. In other words, each party bears its own costs. And that's
so there's already an example of that.
There is, yeah.
That would be a huge win for small businesses, even if there isn't a specialist small business jurisdiction. Just having that implemented and in place would really level the playing field for small businesses in terms of going to court.
I think so. I mean, there's already a disincentive in going to court just by having to pay your own costs. So it's not going to open the floodgates of cases. People are still going to have a good cause of action if they're going to take the risk of even paying for their own costs. And there would always have to be a discretion, I would have thought, to the court to award costs, as happens in the Land and Environment Court, if it turns out that the case really is frivolous or vexatious,
Right.
and really has no merits at all. And that's I think everybody would accept that that's a reasonable way to approach it.
Yeah, you would hope you don't want to waste the court's time. Now, is part of this, hopefully, another aspect of it is how slow and clunky sometimes the court system can be, and the saying of justice delayed is justice denied. Has the report allowed for speeding up the process, or is the fact that if there's a small business jurisdiction, a specialist area, would this speed up the process?
Well, what's proposed, as I understand it, from the Ombudsman, is that it be a division of the Federal Circuit Court, a specialist division that deals just with small business matters. At the moment, the Federal Circuit Court is overstretched and under-resourced, and it's been under-resourced by successive governments. So you've got judges in the Federal Circuit Court having as many as 600 matters in their docket. On average, it's 300 matters on their docket. And if we're going to ensure that there are no big delays, that we're going to improve the system for small business, then we have to ensure that the government is going to put resources into the Federal Circuit Court, so that there's more judges, more registrars, more courts available to sit and hear these matters. Otherwise, it's not going to help in terms of delay.
So is it just resources that's standing in the way of making this a reality?
I think it probably is. It would seem to me that with consultation, the model will be finessed and developed. But as a matter of principle, I think that a lot of people will be behind this idea. So I would hope that the government would listen to that suggestion, and I would hope that some resources could be put into it, because it will certainly serve our small business community that at the moment is really suffering in court proceedings.
Well, we know that as a fallout of COVID, there's going to be a lot of financial disputes coming up. I mean, that was inevitable, whether it's regarding landlords or tenants or any of those multi-aspects that have discovered. Very cheekily, and just to wrap this up now, because we are running out of time, what about, and I'm being a little bit cynical, what kind of lobbying do you think might take place to stop this from happening? Do you think the big end of town might suddenly find itself resourced enough to say, no, we don't want a small business section?
Well, look, there might be some arguments against having it. There might be arguments against there being a non-costs following the event scheme. But really, I don't think that those arguments are going to fly. Any fair-minded person can see that at the moment the system is weighted against small business and in favour of large businesses and government departments with deep pockets. So you've got the small business fighting an insurance company. It's that kind of dynamic where one party's got very little and the other one has a lot. And I don't think any fair-minded person would see it as a bad thing to develop a system that enables cheaper, quicker and more just outcomes.
It's been very much, unfortunately, a David and Goliath kind of routine and system up till now. Pauline Wright, thank you so much for joining us. To everybody viewing, we hope that you've pressed subscribe. If you haven't, it's just a bell and a button. To the Piedmont Studio, thank you so much for making us look and sound good. To the SMEA Association, without you, this wouldn't be possible, so we thank you for your support. If you have any comments, tips, tricks, questions, stories, you can send them straight to me. news@smea.org.au, and we're across all the socials. Pauline, thank you so much. Have a great day, and we look forward to speaking to you again with good news on the implementation of it.
Thanks very much. It's been a pleasure.